Good morning, everyone. I hope everyone's doing well this morning. Courtroom 2, would you let me know when you're all ready to go?
James.
Good morning, Judge Morrow.
Good morning. How are you doing today?
Pretty good, and yourself?
Excellent. Thank you.
We're going to be starting with position number 3, Mr. Callahan.
Yes, ma'am.
Have a seat in the green chair for me.
And this is a negotiated plea, Mr. Dotis?
Yes, Your Honor. Good morning.
Good morning. Good morning, Mr. Callahan. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me?
Yes, sir.
Thank you. Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Callahan. Good morning, Ms. Bickerstaff.
Good morning, Judge Morrow. How are you?
Doing well, thank you.
Good. The state's recommendation is 12 months to serve 26 days, credit for time served 13 days, balance suspended.
Mr. Dotis?
That's our understanding of the offer, Your Honor, and we would stipulate to the factual basis, venue, and ID for the purpose of this plea.
Mr. Callahan, it's my understanding that in case 20 CR 001258E, you wish to plead guilty to obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Callahan. Good luck to you, sir.
Thank you. Thank you.
Position 4, Clark.
What's the announcement on Mr. Clark?
Yes, Your Honor. If I could be placed on mute 1 second.
Okay.
Thank you, Your Honor. This will be a non-negotiated plea. Our only issue is the stay away address. Additionally, we would request, Mr. Clark would request to enter a plea of nolo contendere on these charges.
Okay, so you don't contest the no further contact with the victim, and what's the issue with the address?
This is Mr. Clark's address. So we would ask for a one-time sheriff's escort to make sure that the victim does not live at that location. Mr. Clark tells me she does not live at that location and won't come back, and he's fine with the no further contact. But this is his apartment. His name is on the lease, and if he can't return, then he will be homeless.
Okay, so what you're requesting is a one-time police escort to make sure that Ms. Lowe is not at the address. If she's not at the address, he can stay. If he is at the address, he'll have to obtain his belongings and find someplace else to reside. Is that correct?
Correct, Your Honor. He's clear on that.
Okay, any objection to that, Ms. Bickerstaff?
No objection.
Okay, and can you give me the history so I can decide on the no-lo? Ms. Tyson,
Good morning, Your Honor.
good morning.
Defendant has 12 arrest cycles beginning in 1985. He has 1, 2, 3, 4, 5 misdemeanor convictions outside of the 10-year period, and 1, 2, 3, 4 violations of probation. His last arrest was an actual violation of probation. That was March of 2014. Nothing to add, Your Honor.
Can you tell me what he's been convicted of?
Let's see. It looks like for that last violation of probation, the underlying charge was a simple battery, so misdemeanor simple battery. Let's see. I'm looking at the rest of them. Yes, it looks like all the violations of probation were underlying charges was a simple battery.
Okay, thank you, Ms. Tyson. Mr. Dotis, I wouldn't be inclined to offer to allow him to plead no-lo. If he'd like to plead guilty, we can proceed.
Okay, if I could have 1 second on mute, Your Honor.
Okay.
The ASL person will be on.
Mr. Stinson should be, yeah.
Thank you, Your Honor. This is, my client understands and is prepared to continue with the negotiated plea.
Okay, very good. Yes, Ms. Bickerstaff?
Yes, Your Honor. The state's offer is 12 months to serve 32 days, credit for time served 16 days, balance probated to no further contact with Ms. Lowe, to stay away from the 521 Joseph E. Laurie Boulevard if Ms. Lowe is still residing there, and in FVIB.
Okay. Good morning, Mr. Clark. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you, Mr. Clark. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, sir. Mr. Dotis, anything further?
Your Honor, we would request a break on probation fees to help Mr. Clark get back on his feet and to switch to non-reporting status upon completion of the FDIP program.
Is he working at the present time?
Mr. Clark is on a disability at this time.
Okay. Mr. Clark, it's my understanding that in case 23 CR 003156Y, you wish to plead guilty to battery, family violence, and battery. Is that correct?
That's correct.
Are you under the influence of any drugs or alcohol this morning?
Nope.
You've been represented by counsel. Are you satisfied with his representation?
Yeah.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Nope.
I'll accept the plea as negotiated. Mr. Clark, I am going to waive 2 months of your probation fees to help you get on your feet. Once you complete the terms of the probation, it'll go to a non-reporting status. So the sooner you complete the probation requirements, the sooner you won't have to report to probation, okay?
Okay.
All right, good luck to you, sir.
Judge Morrow, I have a quick announcement.
Okay,
The add-on position 4, do we have an interpreter?
have we gotten, I know that he was, have we gotten a sign language person for this morning? Good morning, Ms. Strong.
Good morning, Judge Morrow. We are to have a ASL interpreter this morning.
Okay. So apparently we will have one.
Okay, thank you.
All right. Who do we have next?
Position 6, 7, and 8, Fisher.
And these are going to be negotiated, please.
Yes, Your Honor. Mr. Fisher is also here on 2 FTAs, positions 9 and 10, which should be no cross, assuming we go forward with negotiations.
Okay. Good morning, Mr. Fisher. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Ms. Bickerstaff?
Yes, for position 6, the state offers 12 months to serve 18 days, credit for time served 9 days, balance probated to no further contact with Ms. Green, to stay away from 1191 Metropolitan Parkway, in ADET and an FVIB. For position 7, it's 12 months to serve 18 days, credit for time served 9 days, balance suspended, and to stay away from the incident location, which is Alabama Street, the MARTA station on Alabama Street. And for position 8, the state's offer is 12 months to serve 18 days, credit for time served 9 days, balance probated, and to comply with all MARTA suspensions as well as an ADET. And all 3 of these offers are to run concurrent with each other. And then for positions 9 and 10, we'll no pros them.
Mr. Otis?
Thank you, Your Honor. That's our understanding of the offer. Would ask this court to accept them as negotiated. We would ask for position 7, the criminal trespass charge, instead of stay away, since it was a MARTA station, to comply with any active MARTA suspensions. Mr. Fisher is clear on what his active MARTA suspension is. Other than that, we do stipulate to the factual basis, venue, ID for the purpose of this plea.
Any objection, Ms. Bickerstaff?
No objection.
Okay. Mr. Fisher, it's my understanding that in case 22 CR 0052228J, you wish to plead guilty to simple battery, family violence. In case 22 CR 00800J, you wish to plead guilty to criminal trespass. And in case 23 CR 003317J, you wish to plead guilty to criminal trespass, willful obstruction of a law enforcement officer, and public drunkenness. Is that correct?
Correct. Yes.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the pleas as negotiated, Mr. Fisher. When you complete the terms of the probation, it'll go to a non-reporting status. So the sooner you get it done, the sooner you won't have to report to probation, okay?
Yes, sir.
And Your
All
Honor,
right.
Mr. Fisk does tells me that he lost his job while in custody, so we would ask if this court could waive a few months of his probation to help him get back on his feet.
I'll waive 2 months to allow him to time to find a job.
Thank you, Your Honor.
Okay, good luck to you, Mr. Fisher.
Thank you.
This is going to be the probation calendar, positions 8 and 9. Oglesby, that's for Ms. McLeod.
Yes, good morning, Ms. McLeod. How are you today?
Good morning, Your Honor. I'm fine, thank you.
Let's see. Who do we have on for probation? Oh, Officer Allison, good morning.
Good morning.
Good morning, Mr. Oglesby. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Yes, Officer Allison.
Yes, Mr. Oglesby was pled guilty to simple battery on July 28th, 2022. He failed to pay probation fees. He did not complete domestic violence intervention program. 40 hours community service was not completed. Then he was put on a revocational hearing in front of Judge Edie, which he did not report to. Probation is action to revoke. Mr. Oglesby has 2 months and 16 days left on probation.
Ms. McLeod?
Yes, Your Honor. My client is homeless. He was arrested in December, Your Honor, because he and charged with criminal trespass because he was actually essentially squatting somewhere, he and his girlfriend. He was not employed. He doesn't have any place to live, and that has been really setting him back, Your Honor. He's not able to do community service or to come up with any money to pay for probation fees because of his current status. And quite frankly, he's in jail right now, so he's unlikely to be able to come out and get a job and a roof over his head. When someone doesn't have the basic things like shelter, Your Honor, especially during the wintertime, because I do recall his last arrest, he was sheltering. It was very, very cold, and he was sheltering somewhere, and that was why he was arrested. He got back out, and he was just unable to find any employment or a place to stay. And when you don't have a stable residence, you don't have a job or anything, it's kind of difficult to keep up with probation when you're trying essentially just to survive. And that has been the situation with Mr. Oglesby, Your Honor.
Okay, I understand his plight. As such, I just want him to get this behind him. So I am going to accept the recommendation from probation and revoke the 2 months and 16 days so that he can go ahead and get that behind him so that he can move on from this matter. So we will revoke the remainder of the time. Good luck to you, Mr. Oglesby.
Wait, yes. Okay, can I say something, y'all? Please?
Mr. Oglesby, you have the right to remain silent. Anything you say can be used against you. If you'd like to speak, I'm happy to give you the opportunity to have something to say, Mr. Oglesby, but just know that whatever you say can be used against you. Ms. McLeod, would you like to advise him?
Mr. Oglesby, would you like to call me?
Yes, ma'am, I would like to call you.
Yes. The jail has my number, and you can give me a call.
Okay, what I wanted to say right now, though.
Say to me first, give me a call, Mr. Oglesby, and let us talk about it.
Go ahead and have a seat over there
All
by
right.
the phone. We'll give you a call, Ms. McLeod.
Thank you.
Position 19, Mr. Sims.
And this is going to be an arraignment. Good morning, Mr. McLean.
Good morning. An
Is that
arraignment,
correct?
not guilty.
Okay. Yes, can you hear me, Mr. Sims?
Yes, sir.
Okay, yes, good morning. I'm Judge Eric Mora. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Okay. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Mr. Sims, you've been charged in case 23 CR 003170B with simple battery against a police officer, corrections officer, or detention officer, and willful obstruction of law enforcement officers. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We have access to the actual accusation and we waive a formal reading of it, Your Honor.
Thank you. How do you plead, Mr. Sims? Guilty or not guilty?
Not guilty.
Your not guilty plea will be recorded. Your case will be returned to the division judge and you'll get notification of your next hearing date, sir. Good luck to you.
Yes, sir. Thank you.
Position 20, 21, and 22, Mr. Thomas.
And these are going to be negotiated, please.
That is, Your Honor. Those are.
Okay. Yes, good morning, Mr. Thomas. Can you hear me okay?
Yes, sir.
Mr. Thomas, this is a state all-purpose calendar. I'm Judge Eric Mara. We're conducting this calendar by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. You can put your hand down.
Yes, Your Honor. For position 20, the state's offer is going to be 12 months to serve, 45 days. Credit for time served, 15 days, balance suspended. For position 21, it's going to be 12 months to serve, 45 days. Credit for time served, 15 days, balance suspended, and to stay away from all MARTA. And for position 20, I'm sorry, he only had 2 positions.
Position.
Oh, no, 22 as well. I'm sorry.
Right.
12 months to serve, 45 days, credit for time served, 15 days, balance probated with the conditions of a behavioral health evaluation, 4 weeks anger management, no further contact with the victim whose name is Tina Taylor, and to stay away from all MARTA. He does currently have a suspension through May of 2025.
Thank you. Let's see, whoever is on Muse iPhone, sir, sir, you're on Muse iPhone, you need to either turn your camera off or stop walking around, okay? So, thank you, sir. Yes, Mr. McLean.
Your Honor, that does result in several extra jail days, which I calculated 46 divided by 2 equaling 23. And off of 23, it'll be about 8 extra jail days. That's his understanding on 2 of those things. The other matter does involve probation. We've discussed it fully. He asked the court to accept his negotiated plea of guilty. He stipulates to venue, identification, and factual evidence.
Okay. Mr. Thomas, it's my understanding that in case 21 CR 002473G, you wish to plead guilty to theft by taking. In case 23 CR 002344G, you wish to plead guilty to certain acts on a bus rail station prohibited and criminal trespass. And in case 23 CR 003172G, you wish to plead guilty to simple battery. Is that correct?
That's correct.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, I am.
Do you understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
I know, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the pleas as negotiated, Mr. Thomas. When you complete the terms of the probation, they'll go to a non-reporting status. So the sooner you complete the terms, the sooner you won't have to report to probation, okay?
Thanks, sir.
All right, good luck to you, Mr. Thomas.
Thank you, Your Honor.
Okay, and let me just make a general announcement. we're very happy to have those of you that are with us this morning, that if you're at home or if you're at work, wherever you are, but please know that this is a privilege to be able to be on a Zoom call this morning. So what I need for you to do is treat this call as though you're actually in court with me. So there should be no moving around or things of that nature. It can be distracting for the court. So please take that into consideration. But we're happy to have you here this morning, and we are happy to acknowledge you when we get to the case that you're here for. Okay, so we appreciate your compliance. Thank you. Who do we have next?
This is the probation calendar, positions 1 and 2, Abney.
Yes, good morning. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Yes, Officer Allison.
Mr. Abney was pled guilty to loitering on September 12th, 2022. He failed to pay probation fees. He has a court fine of $690. He has not reported to probation at all. And then he failed to complete a shoplifting course. He has 5 months, 16 days left. Probation request is to revoke.
Mr. Doders?
Thank you, Your Honor. In September of 2022, Mr. Abney did resolve this case by entering a plea pro se. After resolving this matter, he did have a separate matter in Douglasville that held him from September to November. Upon release in November, he wasn't clear on what was required of him regarding this plea and his situation in Douglasville, and was under the impression that someone would reach out. He understands that was not a correct assumption, and that he should have been the one to reach out as soon as custody, but he was dealing with 2 separate matters. Again, he was also in custody on another matter in Cobb County from March until last week when he was transferred to Fulton County custody, where this is now the last of his legal matters that are holding him. He understands what is required of him to be successful moving forward, if given the opportunity by this court for a second chance to complete that anti-theft course and report to probation. If given the opportunity to be reinstated, he's clear that he will need to report immediately and get started on a theft course. I've provided Mr. Abney with probation's contact information and address, and I've also given him one of the anti-theft programs that our office recommends. So he has all the tools he needs to be successful if given the chance to do so. I also have good contact information with Mr. Abney, who will be living with mom. So I have a contact information to provide to probation, and he will have his mother's support, but he is clear that if given the opportunity, he will need to report immediately and immediately get started on this anti-theft program.
Okay. Mr. Abney, I'm going to give you the opportunity to do what you told the court you would do in the beginning. But if you miss one time from reporting from probation, I'm going to have Officer Allison have you come back, and I'm going to revoke the remainder of whatever's left at that time, and you'll be right back where you are. So I'm going to give you the opportunity to be responsible and to do this, but just know that if you don't, the next time, if there is a next time, that I will be revoking. Okay.
Yes, Your Honor.
All right. So I'm going to reinstate you at the present time. He's supposed to report once a month, Officer Allison.
Yes.
Okay. Well, if he misses one time from reporting, please have him back.
Okay. Can we do a report within 48 hours upon release?
Mr. Douglas, can he report within 48 hours?
Your Honor, I would ask to report maybe by, I don't know what days we can report. I'm under the impression it was Tuesdays and Thursdays. I'm not sure when the jail would be releasing him. It could be sometime Friday. Could we report by next Thursday?
Yes, that's fine.
Yeah, that's fine. Next week. All right. Good luck to you, Mr. Abney.
Thank you, Your Honor. Mr. Abney.
You're welcome.
Just in case, contact another sheet. Okay.
This is the probation calendar, positions 3 and 4. Mr. Bell.
Good morning, Mr. Bell. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Yes, Officer Allison.
Yes, Mr. Bell was put on probation for 12 months in February 23rd, 2023. He has a court fine of $724.50. He did not report on occasion of 2 times. He only reported once. He failed to complete a drug and alcohol evaluation, did not complete drug screens. 40 hours of community service was not completed. Risk reduction course was not completed. He missed a revocational hearing on April 25th of 2023, and he did not complete a victim impact panel. Probation is asking to continue him on probation. He has 10 months, 8 days left. But we want to do, he has 30 days to complete an evaluation, and then start community service within 2 weeks. Then report to probation within 48 hours upon release.
Mr. Gaddis?
Yes, Your Honor, we would ask this court to accept probation's recommendation upon his resolution of this case. Mr. Bell was residentially challenged and struggled with meeting his obligations. I do have an updated contact information now, along with a phone number and an address for his sister, who I believe will be supporting him. I've also provided him with probation's contact information and housing assistance in case there are any issues in the future. He is clear on what's required of him, including reporting as soon as possible. As stated previously, we would ask it just to be worded as report by next Thursday, since we're not clear on exactly when Mr. Bell would be released, and I don't want him to be in danger of immediately violating if he cannot make it to probation within 48 hours.
That's fine with the court. Officer Allison, any problem with that?
Nope, that's fine with me.
Okay. We'll give you that opportunity, Mr. Bell. But make sure that you continue, or that you report to probation on a regular basis when you're scheduled, okay?
Yes, sir.
All right, good luck to you, sir.
Position 13, Mr. Gay.
And this is a negotiated plea.
Yes, Your Honor, this will be negotiated.
Good morning, Mr. Gay. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Gay. Ms. Bickerstaff?
Yes, the state's offers 12 months to serve 28 days, credit for time served 14 days, balance suspended, and to stay away from the Texaco at 2067 Delow Drive.
Mr. Dudas?
Yes, Your Honor, that's our understanding of the offer. We would ask the court to accept it. We do stipulate to the factual basis, venue, and ID for the purpose of this plea.
Mr. Gay, it's my understanding that in case 23 CR 003215C that you wish to plead guilty to criminal trespass, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
Oh.
Okay, I'll accept your plea as negotiated, Mr. Gay. You know you can't go back to that Texaco on Delow, okay?
All right.
All right, good luck to you, sir.
Position 14, Mr. Hicks.
Also a negotiated plea.
It is.
Good morning, Mr. Hicks. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Ms. Bickerstaff?
Yes, the state's offer is 12 months to serve, 150 days, credit for time served, 10 days, balance probated to an FVIB to stay away from the incident location and no further contact with the victims in this case.
Okay, can you tell me the stay away and the victims?
Yes, Your Honor, just one second. Let me go back to it. So the victims in this case are Shakia Shaw, SHEKIA, and Jacinta Jones, JACINTA, and Larisha Shaw, LARESHA. And then I'm looking for, let me come back to you with the stay away location because I do not see the police report in Odyssey right now, but I'll find it.
Okay, Mr. McLean?
Your Honor, he's very familiar with the case. He's just spent several years in incarceration. Ideally, practically, this should have been taken care of years ago with the detainer letter and would not involve him spending an extra 60 days calculated. However, after fully discussing all the possibilities of what could be the consequences of going forward in another direction, he chooses to accept the state's offer. We've discussed that fully. Therefore, Your Honor, he'd like to ask the court to accept his negotiated plea of guilty based on his stipulation of venue, identification, and factual basis.
Okay. Did you find the address, Ms. Bickerstaff?
I'm still looking, Your Honor.
He's familiar. He's familiar with all the facts, Your Honor. So if you say instant location, he knows where to stay away from.
Mr. Hicks, it's my understanding that in case 17 CR 022266G, you wish to plead guilty to 2 counts of simple battery, 2 counts of battery family violence, 1 count of simple battery family violence, and a count of battery against a female who is pregnant. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you've given up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Hicks. Good luck to you, sir.
Thank you, Your Honor. I'll provide him again with, we discussed last night, the 132 Mitchell Street address of probation and the FVIP, so I'll make sure he is on top of that.
Okay, thank you, Mr. McLean.
Excuse me, Judge Morrow. Ms. Bickerstaff, when you find the address, can you put it in the chat, please?
Yes.
Thank you.
Mhm.
Position 18, Owens.
Yeah. That's a negotiated plea, Your Honor.
Okay, good morning, Mr. Owens. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, sir. Yes, Mr. Walker.
Yes, Your Honor. The state's recommendation is 12 months to serve 30 days, credit for time served 15 days, balance probated with the condition of an alcohol drug evaluation and any necessary treatment.
Mr. McLean,
Your Honor, he understands how the ADET recommendation or actual condition works, and he will probably seek that ADE at grading. Your Honor, he understands about probation. We would ask the court to accept his negotiated plea of guilty while we stipulate to venue identification and factual basis.
Mr. Owens, it's my understanding that in case 23 CR 003183G, you wish to plead guilty to pedestrian and roadway and public drunk. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir, I do.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated. Mr. Owens, when you complete the ADET requirement, the probation is going to terminate. So the sooner you get through that, the sooner you won't be on probation, okay?
Yes, sir.
All right.
There are some cases by their very nature when a person is residentially challenged that the contact sheet is going to be slim pickings. It's going to be kind of lean. We want to give a heads up to the probation department on that. He should report as soon as he can.
Okay. Good luck to you, Mr. Owens.
On 3 South, I have Mr. Floyd. I guess it's position number 17, I guess.
What's the last name?
Floyd.
11.
I'm sorry, position number 11.
Okay.
And if I could have the jail iPhone call courtroom for a quick conversation with Mr. Floyd.
Okay, hold on, though. This is calling now.
Thanks, Floyd.
Your Honor, we have a new announcement.
Okay.
On position, Mr. LaRon Walker, position number something. That would be a request for a week. I want to check on something very simple, but it involves getting a phone call returned to me. So if we could reset that a week, I'd appreciate it.
And Your Honor, that's fine. I do want to recognize that the victim, Mr. Fitton, is on the Zoom.
Okay, thank you. So Mr. Walker's case will be reset until next Thursday, which is June 8th.
Thank you, Your Honor.
And we will, Mr. Walker, your office will contact the alleged victim in the case to update him also. Is that
Thank you.
correct?
That is
All right,
correct.
thank you. Thank you.
And Your Honor, we are already on position 11.
Okay. And what's the announcement?
Yes, Your Honor, we'll be waiving arraignment and entering plea of not guilty today and asking to address bond.
Let's see, can I get Mr. Floyd's history, please?
Hey, I'm just letting you know you have another.
Yes, Your Honor. 1 second. This is Matthew Floyd, correct?
That's correct.
Okay. All right, Your Honor, the defendant has 5 arrest cycles beginning in 2005. He has 1 misdemeanor conviction out of Cobb County for simple battery, willful obstruction of law enforcement officer. Disposition date on that is June 2013. Defendant has 1 violation of probation, and his last arrest was February of 2023 for aggravated assault, possession of a firearm or knife during the commission of certain felonies, and willful obstruction of law enforcement officer. I was trying to see. They do have a 23 CP case in Odyssey, but the status says that it's been transferred, but there's nothing else. And I don't see anything else in the system.
Thank you. What's his current bond?
It's a $2,000 surety bond, Your Honor.
Say it again.
$2,000 surety bond, Your Honor. It's 1,000 on each count. It doesn't release a bond for the second disorderly conduct at this time.
Ms. Bickerstaff?
Yes, Your Honor. So this incident occurred February 11th, 2023 at the intersection of Piedmont Road and Lakeshore Drive. And this is when, after having a dangerous altercation with 2 citizens in the community, this is where the defendant pulled out a knife and threw the knife at the 2 gentlemen. Officers arrived and told the defendant to stop walking backwards away from the officer, and the defendant did not stop walking backwards. And then he eventually ran out the back door of a nearby store. And then after a brief chase, officers were able to catch him, but they had to tase the defendant to get him to comply with verbal orders to surrender, Your Honor.
Okay, Mr. Douglas?
Thank you, Your Honor. Mr. Floyd is 35 years old. He has been in custody for 110 days on a $2,000 surety bond for this case alone. He's only had 1 conviction back in 2013. As we heard from pretrial, there was a CP case, but just to clarify, that case was transferred and is now this case. The other charges were dismissed for lack of probable cause. We are asking that $2,000 surety bond to be converted to a signature bond. I have good contact for Mr. Floyd's family who are on the Zoom. I saw Miss Angela Wilson, his sister who I spoke to, and Miss Evelyn Hunter is on the Zoom as well, his mother. Our intention is we'd ask for a signature bond with Mr. Floyd to be released directly to either Ms. Angela Wilson or Evelyn Hunter to go directly to a rehabilitation center. Mr. Floyd has been interviewing with the Potter's House in Jefferson, Georgia. He's waiting today to see if he'll be accepted to that. He has a call at 11 a.m. So we're hoping that he will be accepted and able to go straight from custody to the Potter's House. That is a rehabilitation facility in Jefferson, Georgia. It involves classes for the first 6 months and then a work-based program with them still living on the property. Based on my conversations with the family, we believe that this will help be a program that Mr. Floyd will be successful with, since he's not in the Atlanta, since it's not located in the Atlanta area, and could offer a fresh start to help Mr. Floyd get back on track as he prepares to face these charges. So we would just ask for that surety bond to be converted to a signature bond so that he can be released, transferred directly to the Potter's House. And again, he does have family support, who I have been in contact with to arrange this.
Ms. Bickerstaff, does the state have any objection to the defendant's request?
To being released directly to the Potter House, no, there's no objection to that.
Okay, so if you'll put all that in the order, Mr. Dotis, does he also need a bond for the second disorderly?
Yes, Your Honor, that's not listed on his Odyssey as holding him. I guess we can add that if needed.
Ms. Strong? I just want to make sure that that if he's getting out, that we address all the charges, that he has a bond for everything.
Right, I think that we need to address everything that's on the calendar.
So, Mr. Dotis, if you'll give him also a signature bond on the second disorderly conduct, so that we can make sure that he gets out.
Thank you, Your Honor. I'll confirm that.
So we're amending this to a $3,000 signature bond through the jail.
That's correct.
Okay, thank you.
With the conditions that Mr. Dotis listed and whatever other conditions were on the original bond. Okay.
Thank you, Your Honor. Ms. Floyd and Ms. Wilson, or Ms. Hunter and Ms. Wilson, I'll be in contact on where to go forward from here. Thank you.
All right. Good luck to you, Mr. Floyd.
Thank you.
Position 24, Mr. Watson.
That's a negotiated plea.
Good morning, Mr. Watson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down. Yes, Mr. Walker.
Yes, Your Honor, the state's recommendation is 12 months to serve, 24 days, credit for time served, 12 days, balance probated with the condition of a theft course and a stay away from the Apple Store located at 3393 Peachtree Road or Lenox Mall.
Mr. McLean.
Yes, Your Honor, he asked the court to accept his negotiated plea of guilty while he stipulates to venue and identification and factual basis. He understands his obligations to take a theft course and to be on probation. We've talked about the cost of those. Your Honor, he does have financial problems, so we wondered if the court could give him a break on the probation fees for a couple of months while he's taking that theft course. That'll run him a couple $100.
You should be able to get through the theft course in the first month of being released. I will allow the probation to terminate once he has taken that theft course, though. Okay.
Thank you, Your Honor.
Mr. Watson, it's my understanding that in case 21 CR 003518Y, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the negotiated plea, Mr. Watson. As soon as you complete the theft course, the probation will terminate. So the sooner you get that done, the sooner you won't be on probation, okay?
Thank you, Your Honor.
All right, good luck to you, sir.
Measure out the bridge.
This is gonna be on the add-on calendar, position 3, Mr. Martin. That's Ms. McLeod's case.
Your Honor, this is Officer Milton. Give me about 10 minutes and I'll be, well, 15 minutes and I'll be back with the people for probation revocation. But first I will bring Ms. Rockwell client Hunt. I'll bring him first before I bring the females.
All right, very good. Thank you.
Thank you.
And let's see, this is what are we doing with Mr. Martin this morning, Ms. McLeod?
Your Honor, I'm not sure because I haven't had a chance to talk with him and I was unaware that he was on the calendar.
Okay.
I'll have him call you, Ms. McLeod.
Let's see, do you have the offer?
I do not, Your Honor.
Okay, Ms. Bickerstaff, what is the offer in this?
The
Mr.
offer
Martin.
is 12 months to serve 365 days, credit for time served 17 days.
Given that that's the offer, Ms. McLeod, I'd like to give you the opportunity to speak with him in detail, given what they're asking. Would you like me to reset this till next Tuesday?
Yes, Your Honor.
Okay.
I would
So,
appreciate it.
yes, I'm going to give Mr. Martin, I'm going to give your lawyer the opportunity to talk with you about the case in detail. So I'll reset your case until next Tuesday. Okay, so we'll see you back next Tuesday.
Yes, sir.
Thank you.
And Your Honor, I have a client in mental health court at 10 o'clock, so I have to go to a different link. May I be excused for that?
Yes, yes, Mr. McLeod, thank you.
You're welcome. Thank you.
Position 25, Mr. Williams.
That's a negotiated plea, Your Honor.
Yes, good morning, Mr. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Mr. Walker?
Yes, Your Honor, the state's recommendation is 12 months to serve 26 days, credit for time served 13 days, balance probated with the condition of an alcohol drug evaluation with any necessary treatment.
Mr. McLean?
Your Honor, I recommended to Mr. Williams that if he can't get it anywhere else, be sure to at least go to Grady for the ADET and see if he can get it for a reduced price or for free. Your Honor, he understands the conditions of probation. He understands that probation requires going to 132 Mitchell Street. He asked the court to accept his negotiated plea of guilty. He stipulates to a factual basis, venue, and identification.
Mr. Williams, it's my understanding that in case 23 CR 003207F, you wish to plead guilty to pedestrian under the influence, willful obstruction of a law enforcement officer, and pedestrian and roadway. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Williams. As soon as you complete the the ADET, the probation will go to a non-reporting status. So the sooner you don't, sooner you get done with that, the sooner you won't have to report to probation, okay?
Yes, sir. Thank
Good
you.
luck to you, sir.
Thank you. All right, man. Get it done. All right. Stay in touch with your uncle.
This is on the probation calendar, positions 5 and 6. Mr. Days.
Yes, good morning, Mr. Days. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes,
Your
sir.
Honor, sir, yes, sir.
I apologize,
Thank you.
Your Honor. I do need to talk to him first.
Okay. Okay, you want to, are you gonna need how much time are you gonna need? Do you want him to stay there and you talk to him there and go on mute, or do you need?
We have
some
a
time?
back corner in which we can whisper. If we have a good 10 minutes, I think we can decide whether to ask for a reset or go forward.
Okay, that's fine, Mr. McLean.
Thank you.
Do we have any of Mr. Dodez's cases that we can take? I'm not sure.
All
if
his
we-
cases are done. I do also have probations. Can you do, McLean, can you do probation 7, Mr. Hurst?
Mr. Hurst.
This is gonna be probation, position number 7, Mr. Hurst.
Same thing.
You need to talk to him as well?
Yes.
That's all I have left, Judge.
Okay, so I guess we'll be in recess until someone comes back, Mr. McLean comes back, or either Officer Milton brings someone for us.
And Your Honor, I do have, while we're waiting, I do have an announcement for positions 1 and 5. If we could speak about those while we have a second.
Okay,
Yes, Your Honor, for position 1, Mr. Baker, I've been informed by jail staff that he was released on May 18th. That's not accurately reflected in Odyssey at this time. So I would ask for a 1-week reset to control to make sure that he's not, just to confirm that he is in fact not in custody.
okay, he'll be reset until next Thursday, which is the 8th.
Thank you, Your Honor. And then for position 5, Mr. Davis, that is a medical reset for, we'd request 1 week out.
Okay, also reset for next Thursday, I'm sorry, June 8th.
Thank you, Your Honor.
Ms. Champion,
Yes, sir.
so are we requesting another ASL interpreter today, or will
Yes,
we
we're
need-
trying to see if we can get one to log on for today. I'm
Okay.
not quite sure if we're gonna be successful with that at this time.
Okay, just let us know. Thank you. We appreciate it.
Ready on 2 probation cases, Hurst and Days.
Okay,
This is probation 7, Mr. Hurst.
yes, good morning, Mr. Hurst. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Yes, Officer Allison.
Yes, he was sentenced to 12 months probation, February 19th of 2019. He owes a court fine of $1,149. He does owe probation supervision fees of $120, and then the victim foundation of $27. He stopped reporting and did not return for 4 appointments as directed. Probation is asking for time served. He has 1 month and 23 days left.
Mr. McLean?
Given the nature of the original offense, I think that's very appropriate. Time served sounds wonderful. We would ask the court to accept that.
All right, I'll accept probation's recommendation. Good luck to you, Mr. Hurst.
Thank you, sir. No. Days. Mr. Days is sitting beside me, Your Honor.
Yes, good morning, Mr. Days. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir, yes, sir.
Thank you. Yes, Officer Allison.
Yes, Mr. Days was sentenced to 12 months probation September 27th of 2022 on the offense of simply battery. He did not report on a total of 2 times. He was directed to complete a family violence intervention program. He missed a hearing with Judge Roth on February 13th of 2023. He has 5 months, 8 days left. That is not enough time to complete the program. Probation is asking to revoke.
I'm sorry. Tell me again what he did not do.
He didn't report. He didn't do a family violence intervention program.
Okay. Mr. McLean?
Your Honor, we do understand the calendar program. I discussed with him the fact that if he even had 5.5 to 6 months left on his probation, that he could squeeze in that DVIP, also known as FVIP. I asked him as to what on earth was his understanding of his obligations at the time that he went on probation. He said that he had some mail problems because the mail was going to the address that he was told to stay away from, and he obeyed the stay away. Unfortunately, he didn't make other arrangements about the mail. He seems to be a bit confused about FVIP. I don't know. I don't know why he didn't understand the 24 weeks and the nature of the length of it and the expense of it, because it is quite a program, and it's no joke. It's not small. But, Your Honor, he was driving local truck. Now, when he says local truck, he was basically working for one trucking company and also for a second company, Peach State Movers. So he is an industrious person. He was working his tail end off, Your Honor. He was working and working. And when he messed up his probation, he kept trying to see about what he could do in this sense only. He made phone calls. When he got out of jail, he lost that job with Peach State Movers. He also lost the job with the other. he got kind of down. He got kind of depressed. He was looking for a job and looking for a job. He had lost 2 jobs that were paying him good money, and he just blew it. But he throws himself on the mercy of the court and asks if there's anything besides the DVIP, realizing there's not enough time to actually complete the program as it is structured. Is there anything else he could do to try to prove himself?
I'd rather him do something than nothing, Mr. McLean. So what I'm going to do is I am going to convert the FVIP into 12 weeks of anger management. I'm going to direct probation that he is to report within the next week, and that he is to start the anger management within the next 2 weeks and provide proof that he's done that. If he does not start the anger management or if he does not report to probation, I'm going to have Officer Allison have him back here immediately, and the time that's remaining will be revoked. So Mr. Days, I'm going to give you the opportunity to get something done, but if you do not take that opportunity, then you're going to be right back where you are. You understand me?
Sir, yes, sir.
All right. Good luck to you, Mr. Days.
Thank you, sir.
Thank you, Your Honor.
Your Honor, that's all for probation. Can probation be excused?
Yes, thank you so much. Have a good rest of your day.
You too.
No. He converted the.
And Your Honor, that's what we have in our courtroom too.
Okay,
To the competency starts.
all right, thank you.
Sometimes you will see management abbreviated.
Mr. Howard,
Yes, Judge.
do we have everyone here? Do you know for the competency calendar, can we?
Yes, Judge, we'll be ready shortly. I'm speaking with one person now, but after him, we'll be ready if you want to start on that calendar.
Okay, I've gotten a text from Judge Law, who tells me that she is apparently in court somewhere twiddling her thumbs, and that she can help me out on that calendar, so I can complete this calendar if you all would like me to get in touch with her to move forward on that calendar.
No, we're fine. We can, it sounds like it's not a whole lot of people left anyway.
Okay.
Wait for you.
Okay, all right, I'll let her know. Thank you.
We ready, Your Honor, with Mr. Hunt at ACDC.
Okay.
My apologies. Good morning to everybody.
Good morning. Can you tell me what position that is?
I forgot. I don't have my paperwork with me, Your Honor.
Okay.
Kelvin Hunt.
Hunt?
Yes.
Okay. That's position number 15. Yes. Good morning, Ms. Rockwell. How are you today?
Perfect, Judge. Thank you so much. And thank you for having us.
And what are we going to do with Mr. Hunt today?
Judge, I've submitted paperwork on him. We had reset him so we could take care of a probation issue. Looks like that's been handled, Judge. And we asked that the court entertain a negotiated plea on him.
Okay, very good. Good morning, Mr. Hunt. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Hunt. Yes, Ms. Bickerstaff.
Yes, the state's offer is 12 months to serve, 158 days, credit for time served, 79 days, balance probated to the condition of taking a driving course.
Okay. Ms. Rockwell?
I think the last time the paperwork I filled out, Judge, that was submitted to me was the paperwork that said, to revoke 58 days. Of course, that's the old amount of jail time. He's been sitting in jail for a little while. So I do understand that the prosecutor's offer regarding the different amount of days. I just did not discuss with him the defensive driving course. That was not discussed. That wasn't part of the original offer. It is not an unreasonable request. Of course, it's not in the paperwork that I filled out and signed and returned. I filled out on behalf of Mr. Hunt.
Okay, is he willing to do the driving course, Ms. Rockwell?
Absolutely, Judge, as long as we can figure out how to do that online, because when he gets released, he's planning on going into a rehab center in Dahlonega called Mount Sinai. Would that be okay? Could that be added, that he could complete it online? I've got several online courses, Judge, that are totally legitimate. They're allowed by the City of Atlanta Traffic Court, Municipal Court, and also I've got some online courses that I've suggested to folks that it seems like the state court is approving. So if somebody could just send me some potential online courses, I'd ask Your Honor to accept the plea with that added condition, as long as he'd be able to do it
Online, that's fine with the court. So as long as he gets it complete, that'll be fine. All right, anything further? And it's my understanding that it's a time served plea with the addition of the driving course. Once he completes the driving course, I'm gonna have the probation terminate. So he won't be on probation.
Thank you so
Okay.
much. He could just get reporting instructions. And that's the only thing, Judge. He's on felony probation that just got reinstated and state probation. I'd rather the court put no driving without a valid license, et cetera, something like that. I hate with the suspended sentence. I'm scared of him having to report to two separate probation officers, especially when he's trying to go into this rehab facility.
What's the name of the rehab facility?
It's called Mount Sinai. It's a rehab facility in Dahlonega, Judge. And it's going to take a village, as you know, just to get him there. I've been in communication with his mother. It's something that we've anticipated. Once he gets a little bit close to the door, he's been trying to take care of his felony probation and his misdemeanors.
Your Honor, this is new information to the state, but that's fine. If the court will allow it to be balance suspended and maybe with the condition to report to rehab.
Okay, that's
fine with the state.
So it'll be 12 months to serve, 158 days, credit for time served, 98 days, balance suspended, with the condition that once he's released, that he reports to the treatment facility. Is that fine, Ms. Rockwell?
That's fine, Judge. And could the court or the clerk just pencil that in on my submitted?
Okay.
Thank you, Judge.
Yes, I can do that. Anything further before I take the plea?
Judge just said he's 32, born in Atlanta, went to Whitewater High School, also graduated in 2008, then went to Georgia Southern, studied business, not married, 1 8-year-old daughter, and he's typically gainfully employed as a medical assistant. Other than his rehab, Judge, that he's sought out and wants to attend, we ask that you accept the negotiated plea.
Okay, very good. Mr. Hunt, it's my understanding that in case 22 CR 002394G, you wish to plead guilty to fleeing or attempting to elude a police officer and speeding. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Yes, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you've given up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, which will be 12 months to serve, 158 days, credit for time served, 79 days, balance suspended, and you're to report to the rehab upon release. All right, good luck to you, Mr. Hunt.
Yes, sir.
Anything further this morning, Ms. Rockwell? You
That's
have
all,
a good-
Matt.
Yes,
Thank
you
you.
all have a good day.
Your Honor, I'm going to get Brittany Jackson and Shakita Kane.
Okay, thank you.
Attorney Dodas, please pick up the phone. It's ringing. Yeah. Oh.
Francois, can you hear me?
Yes.
I'm not talking to you, sir.
Hey, Duffy.
Hey, do we have an interpreter yet? Because I need
No,
to.
The sign language, that's, who deals with that? I think that's Ms. Strong.
Denson.
Let me ask Ms. Strong. Hold on one second. I don't know.
The sign language interpreter was not able to make it. We're trying to get another one to come in, but we're not been successful this time.
I can't hear. Duffy, were you able to hear that? I didn't hear. I'm sorry.
They said they're trying to get another one because the first one couldn't make it.
Okay, so it's still working. Okay. Duffy, you heard that?
Yes, I did.
Okay. I just got a lot of noise over here in the courtroom. All right. Yeah, that was you. Mhm.
Should we try to do competency?
Yeah, Mr. Derek is gonna go to the car to start his Zoom, so they should be starting that shortly.
Okay.
We're ready with, position add-on 1, Shakita Kane, Your Honor.
Okay, what are we doing with Ms. Kane today, Mr. Dodas?
Thank you, Your Honor. I conveyed an offer and Ms. Kane indicated she wanted to accept that offer, so this will be a negotiated.
Good morning, Ms. Kane. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, ma'am. Yes, Mr. Walker?
Yes, Your Honor. The state's recommendation is 12 months to serve 26 days, credit for time served 13 days, balance probated with the conditions of a 4-week anger management course, and no further contact with Antonio Curtis.
Mr. Dodas?
Thank you, Your Honor. Ms. Kane is clear on the terms, and we would ask this court to accept the, apologies for the noise, negotiated offer, and we do stipulate to the factual basis, venue, and ID for the purpose of this plea. We would ask this court, if there's no objection, to switching over to non-reporting status upon completion of the 4 weeks of anger management. She has a list of resources and probation's numbers, so she should be able to knock that out quickly. We would also ask this, Your Honor, to waive a few months of her probation in order to give her an opportunity to land on her feet and knock those out. But we are prepared to move forward.
Okay, I'll allow it to go non-reporting. She should be able to get the 4 weeks of anger management done relatively quickly, so that she won't be on reporting probation. Anything further?
Nothing.
And if you can unmute ACDC. Thank you. Ms. Kane, it's my understanding that in case 22 CR 003252Y, you wish to plead guilty to simple battery. Is that correct? Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you've given up your right to a trial by jury? You don't want a jury trial, do you? Okay. Has anyone forced or coerced you to plead guilty?
I'm sorry.
Has anyone forced you to plead guilty? I'll accept the plea as negotiated, Ms. Kane. As soon as you complete the anger management course, the probation will go to a non-reporting status. So as soon as you get that done, the sooner you won't be on reporting probation, okay?
Okay.
All right, good luck to you, ma'am.
All right, thank you.
As soon as Mr. McLean, as soon as Mr. McLean finishes talking to his client, she'll be coming up.
Okay.
And Your Honor, while we're waiting, it looks like it's for an announcement for position 12. We have a message from, I believe, Milton saying that Ms. Floyd had a separate matter downtown in front of Judge Richardson. So we would request a 1-week reset for position 12.
Okay, we'll reset her until next Thursday.
Thank you, Your Honor.
And Ms. Jackson is position 16, Your Honor.
Are we ready with Ms. Jackson?
Mr. McLean is still speaking with Ms. Jackson.
Oh, okay, that's fine.
I would ask if, I may have missed it earlier, but was there an update on the ASL interpreter?
They're still trying to locate one.
Okay, thank you, Your
Mr.
Honor.
Davis. And are you representing any of the bench warrant cases today, Mr. Dotis? Did you hear me, Mr. Dotis? I'm sorry.
My apologies, Your Honor, I was on mute. I am representing positions 1 and 2. Attorney McLean is representing Mr. Sylvanus Jackson, position 3, who I do see on the Zoom.
Okay, thank you.
Judge Morrow.
Hello?
Mr. Jackson, they'll be with you momentarily. Just mute your screen, please.
Okay, thank you.
Did you see my message, Judge Mar?
I did. It appears, excuse me, it appears that we're not able to get an ASL interpreter today. As such, add-on for Mr. Stinson's case will be reset until next Tuesday.
Judge Mar,
Yes.
Officer Duffy, I'm with Mr. James. I believe his position is 5 on the competency. I wasn't sure. I just lost. Are we ready for the competency yet?
We are still trying to complete the SAP calendar. We have at least one other on there, and then we will be ready for the competency calendar. I don't see, I don't know if Mr. So we'll do the competency calendar as soon as we're done with the SAP calendar, which should be here in a moment. And did you hear the announcement about the ASL interpreter? We're going to have to reset that case till Tuesday.
I got the gist of that, Your Honor, yes.
Okay, very good. Thank you.
He and I communicate, laboriously slowly, but we just pass notes back and forth. So we'll communicate some more. We'll stay in good communication.
Okay, who do we have now at ACDC?
Brittany Jackson.
And what are we doing with Ms. Jackson this morning?
It's a bond request and a not guilty.
Good morning, Ms. Jackson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, I do.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, ma'am. Ms. Jackson, you've been charged in case 23 CR 002791A with battery family violence. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do.
How do you plead, Ms. Jackson? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Let's see, can I get her history, please?
One moment, Your Honor.
What's the current bond also?
$2,000 surety, and I'm sure it's her first arrest, but I'll let pretrial confirm that.
Let's see. Looks like she has 2 cycles in Georgia, 2 arrest cycles in Georgia. I apologize. I'm sorry. It's 1 arrest cycle in Georgia. It resulted in she took a NOLA plea for misdemeanor driving without a license out of Clayton County, and that was March of 2023. She has 3 arrest cycles in Florida, beginning in 2013. And it looks like it appears it's a felony conviction for possession of substance hallucinogens. The disposition states that it says filed, amended, and then the date is January of 2019, but that's all it states. So nothing to add, Your Honor.
Mr. Walker?
Yes, Your Honor. In this case, APD was dispatched to the incident location due to a domestic violence call. Upon arrival, they spoke with the neighbor of the defendant who advised that she heard screaming and hollering coming from the location. She walked over to the defendant's house. The door was open and the neighbor witnessed the defendant choking her juvenile child. Upon speaking with the juvenile child, he stated to law enforcement that he came home. His mother told him to call the police. As he started to call the police, that she began to strangle him. He did have visible scratches on his neck. At that time, she was arrested for battery, family violence. She was given a $2,000 surety bond by this court at first appearance. Based on her history and based on the facts of this case, we feel as though a $2,000 surety is more than reasonable. We ask that the court keep it intact as said.
Mr. McLean?
Your Honor, I'm looking at no violent history here. I understand about the license thing in Clayton County. Your Honor, she can't afford the $2,000 bond. She needs a signature bond. She is vigorously in disagreement with the allegations. She believes that person is biased against her, the equivalent of a family member of her accuser, who is her abuser. So it's a situation where she needs a signature bond badly, or as low as the court can possibly make it.
How old is the juvenile?
He's 13.
And where is he now?
The police officer released him to a friend of the mother. So he didn't state a name. He just said he was released to a friend of the family.
Staying with other family, right? Staying with other family, apparently.
His initials are EJ, and he's 13 years old.
Elijah?
I didn't say his name. I said his initials are EJ.
Oh, I'm sorry.
And he's 13. We have not had contact with the child, but we have had contact with the neighbor who called law enforcement. She stated this is an ongoing issue and she has serious concern for the safety of the juvenile child because this is not the first incident that she's observed.
Information for like homeless.
Has this been reported to DFACS, do you know, Mr. Walker?
That I do not know. It did not mention in the report.
Okay.
She and I discussed DFACS. Let's just say she and I discussed DFACS. She feels that she can explain to DFACS exactly what is going on. She did not choke. She did not strangle or choke her child. She was holding her child. The hold that she had on her child was in the neck area, Your Honor. It was around the neck, but she was not choking or strangling him. She was keeping him from hitting her.
Okay, so what I'm going to do is I'm going to give her a $5,000 signature bond through pretrial per the judge, 1 day anger awareness. she's to have no further contact with the minor EJ unless DFACS gets involved. And if DFACS gets involved, then she is to follow whatever guidelines or orders that DFACS puts into place.
So basically, I would summarize that terms, no contact with EJ unless DFACS says so.
Correct.
Okay.
So I want to make sure that that DFACS is involved, and then we'll let them handle it from that point on. And if they deem that placement is fine, then that's fine with the court. No drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor. Fair enough.
All right. Good luck to you, Ms. Jackson.
Thank you.
No, Mr. Jackson.
Okay. Have you spoken with? Do we have anyone else that we? I know that we still have positions. What are we doing with position 17, Derek Mosley?
Your Honor, he was in the POU, Psychiatric Observation Unit. Based on my reading of the report, it looks like I'm going to have to get with him privately again. We would ask to reset that until I decide whether to simply refer to the competency calendar or not. Probably.
Yeah, a week reset?
That would be appropriate.
Okay, we'll reset this till next Thursday. Have you already, Mr. McLean, have you already spoken with Mr. Jackson on the bench warrant?
So Mr. Jackson on the telephone, yes, Your Honor, we have. We're ready.
Okay. Yes, good morning. Can we go ahead and do that, Mr. Walker?
Yeah, I'm ready, Your Honor.
All right, Mr. Jackson, good morning. This is the DV bench warrant case. Mr. Walker, I take it that Mr. Jackson missed the court date?
Yes, Your Honor. He FTA'd on October the 6th of last year. He was given a $3,000 pretrial bond by you at his first appearance. He's been in FTA status for approximately 8 months. He has not reported to pretrial at least since January. He was ordered to also do an anger awareness course. It's the state's position that it's the defendant's responsibility to make sure that he makes all of his court dates and also to update the address. Again, he's been in FTA status for over 8 months. And from my understanding, he has not been reporting to pretrial. So at this point, we would ask that he's remanded to custody and he post a surety bond.
Yes, Mr. McLean.
First, of course, I would emphasize that it is a 1-count case, a simple battery, family violence, I believe it is. Your Honor, the homelessness and joblessness hit him together. He's in his early 40s. That was pretty discombobulating. He's been looking for another job. He's been a cook at a barbecue food establishment in the area of Godby and Old National, and out of a food truck that was owned by another woman who had to shut up shop because of financial difficulties. The business was not making a go of it, but nonetheless, he's a good cook of good barbecue. However, at the same time that he lost his job, he also lost his home. He does have an aunt that he can visit, and but she can't really take him in. So things just fell apart, and I'll use that word again, discombobulation, when it came to keeping up with administrative matters such as court. He does realize it is important. He did finally put in a address change in May. The October was the date of the missed court date. A return to sender letter was dated in February. He asked the court to give him another chance to keep up with his court dates. He is going to vigorously defend himself. He says this is not a true accusation. He intends to go to trial.
All right, well, my concern in this case is that I gave him a signature bond through pretrial. I understand what you're saying, Mr. McLean, but Mr. Jackson, regardless, you just can't go missing. You know, I gave you the opportunity to, if you stay in touch with people, they'll work with you. But if you just go missing, then we have to track you down, and we don't know where you are. So.
I didn't have no resources. I didn't have a phone or anything. Like I say, it's been a downfall for me, and I'm not running from this case. You know, I want to go ahead and get it handled, even though the accusations are false. I was falsely accused of the accusations, and I tried to come turn myself in. Was it May the 19th or something like that? But I'm not running, Your Honor. I just don't have really nowhere to go. That's it. I'm homeless. I'm out. I can't get my ID to apply for more jobs. It's just been bad for me. I'm not running, though.
Do you have a place where you can get your mail at the present time?
Yes, my aunt's house. I'm back and forth here. That's it. Basically, I'm not really out on the streets. So that's it.
Do you have, Mr. McLean, do you have his aunt's address?
Yes, I believe, is it correct, Mr. Jackson, that is the updated address you gave the clerk?
Yes, sir.
Okay, we're looking at it on Odyssey.
Okay, so what I'm gonna do is, I'm sorry about your circumstance, Mr. Jackson. I'm gonna give you an opportunity. If that's the only address that you can get mailed through, I'm gonna give you that opportunity. What I'm gonna do is I'm gonna set aside on this one occasion, make sure that you stay in touch with whomever that aunt is for your mail. If you miss court again, we won't set it aside the next time. So you make sure that either you call the court and somehow to follow up on your case, or you follow up with your aunt to get notice. Okay, but if you
yes, sir, I have. Can you? I'm sorry.
No, you're fine. Go ahead.
Can you email me anything, like when my court date is coming up or anything? Can you do it through an email? Because I'm really I just have this phone and I'm on Wi-Fi.
If you keep it charged up and you check your email every day, that probably would help a lot. But
right.
Also,
yes, sir.
Don't.
Okay. All right. So on this one occasion, we'll set it aside, Mr. Jackson. All right.
And Your Honor, I need this warrant lifted up off me because
that's what
I've done
that,
Mr. I'm having your counsel set it aside. Okay.
Okay. Thank you so much, Your Honor.
All right. You're welcome. You have a good rest of your day. Make sure you show the next time.
Yes, sir. I will.
Okay. Thank you. Thank you. Do we have Quashawn Alford or Mikhail Evans on the line? All right, so you might want to try to raise them. I want to go into the breakout with the competency calendar. If we can go ahead and do that, Mr. Dodos, I'll give you until we return from there to see if they show.
Thank you, Your Honor.
All right, are we ready for the competency calendar?
The state is ready, Your Honor. I can text Mr. Howard.
Judge Morrow, I have Mr. Gene Lewis, that's position, Mr. Gene Lewis, let me look at the calendar.
I'm sorry, I can't hear.
I think she was trying to tell you that position 6 on the competency calendar is in the courtroom, Judge, and we're prepared to do a plea on that case.
Okay, are we ready to take that plea before we go into the breakout?
Yes,
okay.
Judge.
Yes, I have Mr. Gene Lewis.
Okay, very good. Good afternoon, or good morning, Mr. Gene Lewis. I'm Judge Eric Morrow. This is the competency and state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can put your hand down. Thank you. Mr. Walker?
Yes, Your Honor. The state's recommendation is 12 months to serve, 44 days, credit for time served, 22 days, balance probated with the conditions of an ADET or alcohol drug evaluation and any necessary treatment, and to stay away from the incident location, the Exxon gas station located at 1105 Holcomb Bridge Road.
Judge, we do stipulate to a factual basis venue and ID in relation to this case, and we'd ask the court to accept the plea as negotiated. We would ask that the probation fees be waived for a period of time to allow him to get on his feet financially. And we'd ask that the probation terminate whenever he's able to complete any requirement in terms of conditions or treatment.
Okay. Mr. John Lewis, it's my understanding that in case 23 CR 002920F, you wish to plead guilty to reckless conduct, possession and use of drug-related objects, theft by taking, and one other misdemeanor offense. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
Okay, I'll accept the plea as negotiated, Mr. John Lewis. I will waive 2 months of your probation fees to help you get and stay on your feet. And when you complete the terms of the probation, it will terminate.
Thank you, Your Honor.
All right, good luck to you, sir.
Thank you, Judge.
Position 5, Mr. James.
And we can go on a breakout, Judge. These are people that we can discuss in the breakout.
Okay.
Okay. So I guess they go break down.
Okay, let's see. We're gonna need to go over the calendar, but did anyone from the DV bench warrant calendar show up, Mr. Dotis?
Yes, Your Honor, I spoke with Mr. Evans. We are ready to proceed on his bench warrant here.
Okay, and Mr. Howard, are you still with me? We have someone on the jail court's iPhone. This
Position 5. Mr. James.
Yeah. That's, yeah.
Yeah, Mr. James's case has been reset until the 22nd. So we'll see him back on the 22nd. Okay.
Instead of the 22nd.
Yes, let me let his lawyer talk to him now. Mr. Howard comes back on.
Okay.
While we wait for that, Mr. Evans, I'm Judge Eric Morrow. This is the DV bench warrant case. Mr. Howard.
My stuff is there, so, but I don't.
Okay, I don't see him there. Mr. Walker, I take it that Mr. Evans missed a court date?
Yes, he missed a plea and arraignment with Judge Porter on 5/15/23. Of course, it's the state's position that it's the defendant's responsibility to update the clerk with any change of address. I do not see a return to sender. So we ask that the bench warrant remain in place. If the court does opt to sit it aside, we would request that he at least is arraigned today since he missed his arraignment in front of Judge Porter.
Mr. Dotis?
Thank you, Your Honor. At the time that he was originally given a bond, Mr. Evans was residentially challenged and was not able to provide the court with any contact information. Since that time, he has been able to provide that contact information. I believe it was just updated today. Yes, it looks like Mr. Jordan just added an address to Odyssey at 1130. That is the correct address that Mr. Evans gave to the court on May 26th, now that he's back on his feet, and I did confirm that this is the correct address. So moving forward, Mr. Evans does understand that, this is the address that he needs to keep everything updated with the court. I've also instructed him to check in once a month, just in case there's any issues with his mail. He's currently working steadily with Humana, and he wants to keep working and in order to provide for himself and stay on his feet. So we just ask this court to set aside this bench warrant.
Okay. Do you want me to arraign him this morning, Mr. Dotis, or do you want to file a waiver on his behalf?
Your Honor, we'll file a waiver.
Okay. Mr. Evans, it's this court's policy to give you one opportunity to do the right thing. So next, I'm going to set it aside this time, but if you miss any more court dates, know that if there's a warrant issue, that it won't be set aside in the future, okay? All right, good luck to you, sir. I take it that Mr. Ashford did not show?
Yes, Your Honor, I am not sure why Mr. Alford's not here.
Okay. Mr. Evans has a question, it appears, Mr. Dotis.
Mr. Evans, I'll give you a call as soon as I'm out of the courtroom and have access to a phone again.
I just wanted to know if I was good to get off the Zoom. I didn't know.
Oh, yes, you're free to go.
Okay, thank you.
You're welcome. So, Mr. Howard, I know that you had your client Joe Court's iPhone. Joe Court's iPhone had your client there. I didn't know if you needed to communicate anything to him.
Just Mr. Evans, we'll be coming to see you again. You spoke with Miss Amin Williams, and I'll be coming to see you to touch bases.
Mr.
So
this is Mr. James.
Mr. Howard, it's Mr. James.
Mr. James, I mean, yeah, Mr. James, DeAndre James, Mr. James.
Okay,
So there's nothing further we need today. Yes.
all right, very good, thank you. Let's see, are we ready to go over the calendar? Do we have anyone else? Have we taken care of everyone this morning? Who is on Tracy's iPhone?
Yeah.
Hello?
Yes, yes, ma'am. Who are, how
I'm
can I?
here for, I'm here for, Zarkia Johnson.
Yes, Judge, that's one of the cases that we talked about in the breakout. If I could get her contact information, we can reach out to her. Because she'll be able to give us some additional information that'll be helpful, I'm sure.
Yes.
All right.
Okay, are you able to put that in the chat for me, ma'am?
How would I go about doing that? I don't.
Okay.
Could I just give you the number now?
Yes.
Okay, my number is 404-449-8836.
Okay, and what's your name?
My name is Tracy Ellis, and I'm Zarkia's mom.
Okay.
Okay, and it's 404, correct?
Yes, 449-8836.
Okay, Ms. Ellis, we'll give you a call.
Okay, thank you so much.
Thank you.
Uh-huh.
Yes, Ms. Strong, whenever you're ready.
Position number 1 was reset for June the 8th to confirm that the defendant has been released. Position number 2, I just have that it was reset, but I don't have a date that we reset for. It's
Is
just,
that your case, Mr. Doders?
Yes, Your Honor, we just request a 1-week reset to the the June 8th SAP calendar.
Okay.
Position number 3 was a plea. Position number 4 was a plea. Position number 5 was reset medical. It will be reset for June the 8th. Position number 6 was a plea. 7 was a plea. Position number 8 was a plea. Position number 9 and 10 were null pros. Position number 11 was reset jail jury. Position number 12 was reset for June the 8th SAP. Position number 13 was a plea. Position number 14 was a plea. Position number 15 was a plea. Position number 16 was waived arraignment, reset jail jury. Position number 17 was reset for June the 8th. Position number 18 was was a plea. Position number 19 was arraigned, reset jail jury. Position number 20 was a plea. 21 was a plea. Position 22 was a plea. Position number 23 was reset for June the 8th. And position number 24 was a plea. Position number 25 was a plea. On the add-on calendar, position number 1 was a plea. Position number 2 was null pros. Position number 3 was reset for Tuesday's SAP calendar. And position number 4 was reset for Tuesday's SAP calendar.
And Your Honor, for position 16, Ms. Brittany Jackson, I believe Attorney McLean had a question regarding the bond.
I apologize. It was an amended bond for $5,000 signature bond through pretrial per judge.
And through pretrial, I just didn't quite hear through jail, through pretrial, we got that. Thank you.
Which position is that? I'm sorry.
16.
16.
You said 16?
16 is Brittany Jackson.
Okay. And you want her reporting the pretrial?
Through pretrial.
What level, Your Honor?
Once
Level 1?
yes.
Okay.
Okay,
On the DV bench warrant calendar, position number 1 did not appear. Are we allowing him to reset or?
well, if he requests a reset, but
So
given that he's not here, the bench warrant will stay in place.
Okay. Position number 2 and 3, the bench warrant was set aside. Did I
All
miss?
right,
Is that everything?
I think so. Any questions or concerns from anyone?
Now from the state.
All right, very good. Thank you all. I'll see you next week.
All right, bye-bye.
Thank you.
Have a good rest of the day.
Thank you.